not a forum to publicly demean any group or individual, okay? Then instead of going to that second line and third line, we add citizens and other visitors attending Commissioners Court meetings shall preserve order and decorum and shall neither by conversation or otherwise delay or interrupt the proceeding nor refuse to obey the orders of the presiding officer or rules of the Commissioners Court. Any person making impertinent, profane, slanderous, belittling, or threatening remarks, or who becomes boisterous while addressing and or attending the Commissioners Court may be removed from the Commissioners Courtroom or other designated meeting room, okay, if directed to do it by the presiding officer. And then it also goes on to say, if the presiding officer fails to act, any member of the Commissioners Court may move to require enforcement of the rules. And the affirmative vote of a majority of the Commissioners Court shall require the presiding officer to act, okay? And the goal behind that was to communicate more clearly, because a question came up in the last meeting regarding how do we know rude is rude? How do we know, someone is being out of line? And so hopefully this adds additional clarity to what is courtesy, because we talked about courtesy in a very general format, and we said we all know what courtesy is. But as we talked about, that and some members in this group that are here today and some who are not here said, well, courtesy was not displayed, and so we should not leave it up to communicate what we believe courtesy, everybody thinks courtesy is. So this just outlines that these particular things, slanderous remarks, remarks that are designed to be impolite, remarks that are designed to, threaten, that type of language, when you're addressing the court or a member of the court about any behavior that the court has or has not taken, that's not the way you should do that, and that is not the appropriate response in a meeting. What you say and how you say does matter in the meeting process. You can say some things, but how you say it and what you say, there is a decorum that goes along with that, okay? So again, that modified item number 2, line 2 and line 3, and kind of incorporated more information, because again, before it came out that maybe we really didn't know what that was, what courtesy was. Yes, sir.
Rudy, right. I'd just like to add that, I regret that I was unable to make the last 2 committee meetings, and I'm trying to make up for lost time. I don't want to drag you back into something you've already went through.
No, go ahead.
As I hear what you're reading, to me, it just sounds like you reworded the exact same rules. I would guarantee you that our current county judge would consider it slander for us to discuss the items that seem irrefutably proven in the public eye. So the way you have worded that, we would still have the likelihood of being refused our voice if we wanted to get up and speak about this rather embarrassing incident or any other thing that would potentially attack the integrity of a particular individual of the court or the court as a whole.
And that's what we removed, actually. I see you say we removed. The suggestion was that we remove line number 2, which said, in accordance with the court would not allow a member of the public to question the integrity of the court. So that's been taken out.
I understand that, but you've reworded it in a manner where it's just tomato.
Well, actually, the line 3 in there says any profane, insulting, or threatening language directed toward the court and or any person in the court's presence and or a racial, ethnic, or gender slur or epithets will not be tolerated. That's already in there. And I know you weren't able to make the first 2 meetings, but the concern that came out of those meetings was that the idea of us not being able to question the integrity of somebody based on their behavior should be taken out. And we took that out. Sure. So you can question someone's behavior as their representation, but in questioning their behavior and how they are working and representing you as a constituent, you can't be profane. You can't be slanderous means, for example, and we use it as an example, you're a crook, right? You can't do that and expect that the meeting is going to be conducted orderly and efficiently, okay? Because that is not that's not a statement of fact. That's why.
It's an opinion that I may hold dearly, and I may feel I have proven. And I understand. That's a great example.
We're not going to disagree with your opinion, but you're going to block my right to express in the conduct of the court, okay, if your opinion is not a statement of fact as it relates to somebody's behavior, and it's questioning that person, you're calling them something that has not been vetted, okay? Not by, just my own personal thing, but for me to go out and say, for example, you're a business owner, is that correct? For me to go out and make a statement that you're a crook, okay, do I have the right to do that? Oh, absolutely. But if I go out and say you're a crook, something about your business, X, Y, and Z, that negatively impacted your business, I'm pretty sure that you and I are not going to have that's your right, you can say what you want to say, and I'm okay with that.
It is your right, but it would be my right to litigate against you.
And it is the court's right to set the rules of decorum for the meeting. And I agree what you're saying. Mm-hmm. And what you're doing now, project your business knowledge and expertise on, I have rights and you have rights. You have rights, the court has rights. And so we're trying to balance between how do I, as a member of the public, communicate to the body or an individual my right to say I'm dissatisfied with the work that's being done in some shape, form, or fashion, without going over the line to say, because you're a X, Y, and Z.
Sure.
Right, so that's the key.
I understand.
Address the behavior of the individual, but calling an individual out of his or her name would not be appropriate decorum. Well, in the public meeting.
We have the freedom of speech not to say things that everybody wants to hear and not to say things in the perfect polished manner. Not all of us are as calm and collected as those at this table. And it has been demonstrated that this court has forced people to not get to speak for invalid reasons in the eye of almost everybody who observed it happen. I don't think the wording that you have done is addressing that problem, because you're still leaving too much. If it is already against the law for me to yell fire in a crowded theater, if I came up here and I started making threats at somebody, that's already against the law. It doesn't need to be stated in the rules of decorum, aside from to say, anything that could be considered against the law in public would also be a violation of the decorum of the court. That, I think, would be a nice broad way to deal with that, where it's understood. I mean, obviously, we would hope people would be more respectful than just having a chat on the street corner, because it is the court. But we also have to understand that there are those that are just more vulgar in their lifestyle. They may, accidentally drop a bomb here and there just because they're enthusiastic about the topic. And I would hate to see them get eschewed out of the building, just because they're not as calm and collected as those of us would like them to be.
And I would hate that too, which is why the rules are in place, because you have to be able to conduct yourself in accordance with the environment that you're in. And, I don't disagree that there are some people who have, sometimes we get excited, we get heated, we get passionate. But you have to be able to conduct yourself in a way where you can express your passion and also be respectful of the process. So, without beating around the bush, if I did something and I was on a member of the body that you were concerned about, and you said, Mr. Brown as county commissioner, Mr. Brown as, presiding officer of whatever, Mr. Brown, you failed to represent, what I hold to be, a good public steward, X, Y, and Z, right, with X, Y, and Z behavior. That would be one thing. If you got up and said, Mr. Brown, you're a such and such, and such and such and such and such, and you shouldn't do such and such, and you such and such, that's a whole different situation where you're not addressing my behavior. You're literally either being belittling to me, because you're not reflecting the decorum of saying, yes, you and I can have a conversation and you can address your dissatisfaction, but I do have a name, I do have a position, and just as much as I should respect yours, you should respect mine in communicating that passionate concern about my failures as a steward of your trust, right? So that's the deal. You have to be able to, and we're saying to anybody who wants to participate. But you just can't participate in any way that you feel, because, as you mentioned, and we talked about this last meeting, and we got into a conversation. I don't know where you stand on the U.S. Constitution versus the Texas Constitution. But according to the state of Texas, the Commissioner's Court has the ability and the authority to set the time, place, and manner in how meetings are conducted. Now, if you disagree with that, I get it. But that is operating within the law. So if you were to say that we just want to abide by the law, then the Commissioner's Court, even as of today, would be abiding by the law. But what we're saying is
time, place, and manner.
Manner would be how you address the court. There will be decorum. There will be
procedures, yes,
there will
but
be
again,
manners.
when you don't like what somebody's saying and they may not deliver it as tactfully as we would like, they should have their 3 minutes, unless they do something that is threatening
Correct.
or violating the law. I think it's I don't trust this court to have that much power to say I'm using slander, because I guarantee you our current judge would say I was slanderous if I said some of the things that I think need to be said in this court. And you're still giving too much power to this court to curb free speech.
I'm not giving power to the court. The state of Texas gave power to the court. I just want to clear that up. I'm not giving power to the court. I don't have the authority to empower the commissioner's court, but the state of Texas and your
The purpose of this
legislators.
committee is still granting too much power. It is not addressing, protecting the citizens to be able to speak.
Well, I would say to you again, the citizens can speak, and I don't want to belabor the point, but the citizens can speak, and we have had people get up and speak and communicate their concern without calling a member of the court X, Y, and Z. But once you call a member of the court X, Y, and Z, ma'am or sir, you are out of bounds. And quite honestly, if you and I were having this dialogue right now like we're having, and now we're going back and forth and I get passionate and I start calling you out of your name, you're going to miss everything else I'm talking about. It's not going to come across as I'm concerned about how you're going to hear this person doesn't even understand how to have a general dialogue without resorting to baser thoughts, and that loses people, and we're trying to gain people.
I understand and agree with you, and as a business owner, you asked me to think about it as a business. I can tell you countless times I have had to stand and grin and bear it while somebody who was mad about something totally outside of my control felt the need to vent on me. Did I get to call the police and escort them from the building? No.
You may not be in a public forum, though, where you have many people who are listening to that, and that's a different ballgame too. When you're in a public forum, you've got other people who don't share the same type of speech that you do.
Sure.
You may feel very comfortable in saying or using terms that are a bit more base than other people in the courtroom would.
Right.
So you are subjecting other people in that courtroom to language that they may not be comfortable with and may be totally turned off by what you're saying.
Understood.
Well, if you're trying to gain support for your issue, that's not going to do it.
I agree. Whoever uses profanity or loses their control of their demeanor devalues their argument significantly.
But even some of the descriptive terms that Leonardo is talking about. Let me also bring you back to the first sentence in this section E. It says the Smith County Commissioner's Court is not a forum to publicly demean any group or individual. That section is not talking just about the court. You could have someone stand up at this podium and be thoroughly disgusted with the way that you handle something, a business that you conducted for them, and they have requested to speak publicly. The court has said anybody can speak about anything. There's no rules.
Right.
So they could come up and rake you across the coals and call you anything, suggest any manner of criminal activity on your part. And if there are not some type of boundaries set, the court would have to sit there and let them say it, and you would have to either sit there and hear it, or the public would have to sit there and listen to it,